The Court of Appeals is now in session.
All right, welcome everyone to the Utah Court of Appeals. You've all been here before in the past or in the more recent past. I'm Judge Ryan Tenney. I'll be chairing today's panel. With me are Judges Christensen Forster and Judge Harris. Both of you, I think know the drill, but just to get them on the record again, both have 15 minutes for this argument in this appeal. Mr. Boo will be going first. It looks like he's reserved 5 minutes for rebuttal. If the non-argument attorney could turn off the video and mute themselves, that will help us with bandwidth issues and so forth. Unless there are any further questions, we'll go ahead and proceed.
Thank you, Your Honor. May it please the court, Troy Boer on behalf of Candy Wadsworth. The court's decision need not depend upon the back and forth about who's trustworthy. It's contained in the fact that, as Guy concedes, in fact relies on, his health is such that he is unable to get life insurance, and there's a substantial risk that he will not be here at the time of the balloon payment. The court actually recognized this as well at 17-347 of the record in her order. Under these circumstances, with a $17 million balloon payment to be paid in the future, it is, per se, an abuse of discretion to have no restrictions whatsoever on what Guy does with 40% of the estate that belongs to Candy. No restrictions on whether he creates new LLCs as he did in 2009 when he was anticipating divorce. No restrictions on whether he transfers assets when his death is imminent, if it becomes imminent, to whomever he wants and takes it out of his estate. And under those circumstances, security is absolutely essential. And the trial court's order actually states that the court's already decided the security issue is not available given the age of the parties and Guy's health conditions and the amount of the marital estate. But with all due respect to the trial court, those are reasons why security is required, not reasons why security is not required. And the trial court's solution to this is that Candy can litigate with the heirs of the estate, end quote, if and when Mr. Wadsworth dies before the balloon payment is due. Well, depending on where all the assets are at that point, that's not a possibility. And so what we're asking for today is and we can't ask for any particular type of lien. And the reason for that is so much time has passed in this appeal. When our expedited request was denied, that we have no idea where his assets are. We don't know whether he owns his stock. We don't know whether an LLC owns his stock. We don't know what entities own all of the former marital assets and the 40% of the assets that essentially belong to Candy. And so what we have to have at this point is a reverse and remand that requires that adequate security be put into place, but we have to have an accounting so that we can know what adequate security looks like. We have to know where the assets are, what's in his name, what's not in his name. And I don't think it's a problem if we go down and everything's been taken out of his name. I think at that point, the district court doesn't have to impose liens on entities that aren't before the court, which is just a misunderstanding. The point is that she can say, look, you either liquidate and pay right now, and if it's to your advantage not to, then you have to come up with adequate security and give us an accounting so that we can figure out what that is, so that we know that Candy's going to get her 40% of the marital estate. And I also want to point out that this does not solve the problem in the first appeal. It doesn't solve the problem in the first appeal because you hear things in this brief like there's no problem with security and there's no problem with this payment plan because Guy has such good business sense that he's able to increase the value of the estate over these 5 years. Well, here's the problem with that. I'm sure that's true, but Candy doesn't get rewarded at all for any of that. She has a fixed payment plan and a fixed interest rate. His use of her 40% of the marital estate does not benefit her in the least. It all goes to Guy. And not only does it all go to Guy, he can transfer her 40% of the estate out of his own name to put it beyond her reach when the balloon payment's due, particularly if he dies. And he can put the gains that he's gotten from using her 40% for 5 years and put those beyond her reach as well. And so there is no need for the court to write an opinion to say what type of security is required. If this had been expedited, we might have had those issues in play. But at this point, we don't know where the assets are. And because we have no idea where the assets are, we just need a reversal that says some type of lien or adequate security is required. There needs to be an accounting. And once we know where all the assets are, at that point, the district court is ordered to provide adequate security so the payment will be made. Analogous, I realize it's not the same thing, but perfectly analogous to a jury awarding someone $17 million and the judge deciding that he's going to enter a judgment that says, well, we're just going to have the defendant pay interest to the plaintiff on that $17 million. And then in 5 years, it's going to be due. And then to deny any kind of motion under Rule 62 for security. That is in essence what has happened here. And it is true that the judgment lien, which can be present in some divorces, is not present here because it's exactly like the Supreme Court says alimony payments are. When the payment becomes due, that becomes a mini judgment for the alimony payment. When the payments become due under this payment plan, at that point, there's a judgment lien for that amount, but there's not a judgment lien at the point at which you're still 5 years out from a balloon payment. And so we really need to go down and get adequate security. Yes, Your Honor.
Yeah, so you're not, I guess I misunderstood from your briefing. You're not asking for anything more specific than a vacate and remand and in order to enter adequate security. This isn't adequate, essentially.
We have no choice. I mean, when we wrote the brief, it was quite a long time ago, and we asked for this appeal to be expedited because we were exposed the whole time. And it wasn't expedited. And so we're so far along now that there's so much time has passed that because if we chose a security right now, let's say we chose a lien on his stock in WBC. For all we know, an LLC holds his stock in WBC and he doesn't do it directly. And so we can't ask at this point for any specific type of security. We just need a reversal that it was an abuse of discretion to provide none. And we need to send it back down for the district court to provide adequate security. We just can't do it at this point because we don't know where the assets are.
Okay, and so you don't think we need to get into whether it's a UCC1 lien or an equitable lien or some sort of lien, and you don't think we need to get into whether security should be against interests he owns in various companies or against property he owns or against the what? You don't think we need to get into any of that?
I think you need to get into it only to this extent, and it's not as much as I think your question presupposes. I don't think you need to get into it like you would have a year ago. I think you need to get into it to the extent to make clear that there are plenty of cases, and we've cited them, where UCC loans are appropriate. It's true that you can't just impose one on a non-party. What you do is you go to the party who wants the benefit of the payment plan in this place guy, and you say, you either need to liquidate and pay Candy her 40% of the estate right now, or if you want to keep using her money and gaining and keeping it all for yourself, then you need to provide adequate security. And if the district court says a UCC lien on Wadsworth Brothers is the only way to get security on that much money, then you either need, as having the controlling interest of Wadsworth Brothers construction to get this done, or you have to figure out how to liquidate. And that's your problem. You figure it out, Mr. Wadsworth, because you have to either provide adequate security or liquidate right now and pay, but you don't get to do neither. Yes, Your Honor.
Well, sorry to interrupt, Judge Tenney, but I guess I wonder why we can't just solve the problem by ordering that security be against his interest in whatever he owns, right? I mean, regardless of whether he's changed it to something else, ultimately it's traced back to him somehow, isn't it?
I actually think that this afternoon, the court should enter an order that puts an equitable lien on whatever he happens to own right now. And then we're secured until we get back on remand. And then we can figure out what he actually has and whether he has interest in the company or whether he's put it into irrevocable trusts or things where us having a lien on his interest means we don't get anything out of it. We just need to know where the money is and what he actually owns. But I think this afternoon, the court should enter an order for an equitable lien on whatever he happens to own right now, so that she's secured while we're going back down on remand and doing an accounting. I think that's the solution right now. We can't pick among the other options because we just have no idea what the landscape looks like at this point on his end.
Can I ask you a question? Maybe this is too basic or too generalized. What does the rule look like here? Is the rule that you're proposing the security is always required, or security is only required for what? Fill in the blank there. I mean, I understand your client's position with respect to how much is at stake here in the very particular circumstances of this case, but the opinion that we write will say what to the divorce courts in other smaller cases about this. Help me with that.
You can fashion a rule that's going to provide guidance, or you can fashion a rule that's more tied closely to this case, and I'll explain both.
Yeah.
So the rule that's tied more close to this case is you basically have a finding that Guy Wadsworth is unable to get life insurance. That's what he represents to the court, and the court agreed. If someone is unable to get life insurance and there's a substantial risk of death on the record, and you've got a long enough payment plan that the substantial risk of death makes a substantial risk that the other party is not going to ever see the money, then there has to be some type of security, and you can leave it within the court's discretion to fashion what it is. If you have a very contentious divorce and you have some evidence of the party who would be the payor being very sophisticated and able to hide assets, because that's what's been happening, to try to avoid taxes. Not that it's nefarious, but that's what's been happening since 2009. If you've got someone who's sophisticated on that side, then you have to be able to provide some type of security, but that's going to be a sliding scale. If you don't have a balloon payment, it's less important. If you don't have it stretched out 5 years, it's less important. But here, you've got all of those factors pointing in the exact same direction. You've got the behavior in 2009 when he talks Candy out of pulling her petition and lying about not having an affair, knowing now he's bought time until the next petition is filed, this one. All of the behavior then, so that's pre. You've got the health, and you've got the lack of the ability to get life insurance. You've got $17 million, and you've got a 5-year payment plan, and you've got a 5-year payment plan that barely, if at all, pays interest in the interim. And so he keeps basically 40% of her estate and gets to control it the entire time. With all of those factors, I think you can easily fashion a rule that gets this case, whether it provides guidance. I don't know that you want to provide a lot more guidance in that, because it can be dangerous because you don't know what the next case looks like.
That's what I'm worried about. Right. That makes sense.
Thank you, Your Honor.
Thank you. Ms. Klein.
Thank you. Before I get to my prepared remarks, I want to quickly respond to a few statements by Mr. Boer. First, we don't know whether the balloon payment it's somewhere between 15 and 17 million. The parties have not been, they have different numbers, but that's something that the court will resolve on remand. Doesn't relate to any issues. It's not 17 million. I would note that the trial court denied post-trial discovery on multiple occasions that were seeking exactly what Mr. Boer is arguing for right now, because she found that there was no basis for it, that the requests were based entirely on Candy's distrust of Guy and speculation about what he might do. Despite the parade of horribles that you've heard, Guy is not the scoundrel that Mr. Boer has made him out to be, and that Candy makes him out to be. And the court found that. The life insurance request, I would note, was limited to securing the alimony payments.
Can I stop you there?
Judge Tenney.
Even putting aside whether he is the scoundrel or not, is there anything that is stopping him right now from spending down what exists in the marital estate in the next 5 years?
There is not. No more so than would stop any of this paying spouses in the other cases that have approved equalization payments from doing the same thing.
So putting aside the sort of the scoundrel stuff, I understand your point about that, and you know, we can point fingers on both sides. Their central point seems to be, look, if Candy is entitled to half of the estate, and there's nothing, as you now admit, there's nothing stopping him from spending down the entirety of the estate in the next 5 years, then there's at least the possibility that she's not going to be able to collect on what she's entitled to right now. And that seems to be the problem. So what's the assurance that she gets what she's entitled to?
Let me backtrack. When I said there's nothing to stop him, the premise of your question is that there's a pile of money. That guy's sitting on $15 to $17 million of candies, and he could just be out gambling, doing whatever he wants with it. That's not the situation we have. He has a very small pile of cash. Actually, the court gave Candy, when it awarded her $6.4 million, the vast majority of the liquid and unencumbered assets and cash in their estate. So it doesn't, it's really not a realistic possibility that Guy could be doing what you're saying. Could he be destroying the business? Sure. Could external events arise that make the value of the business less than what it was at the time of valuation? Sure. But that's a different risk than the one that Candy is focusing on. She has this image in her head of Guy really doing everything he can to harm her and squirrel away assets and give them away and do everything he can so that come 2024 there'll be nothing left for her.
Would there be anything that would stop him from doing that, though?
Just his self-interest. And we believe that the court had good reason to assume that he would continue. You know, there's lots of talk about incentivizing in this, in the briefs. He is incentivized to run WBC and the related companies and the restaurants as well as possible because he does anticipate the possibility of having to sell some or all of them. It's in his interest. He'd have to want to burn down the house to hurt Candy the way that she assumes that he will. The fact is, he has complied with every court order when it comes to payment of money or transfer of fund assets to Candy over the course of this case. That includes over $2.2 million in interest at this point, about $635,000 in alimony payments. And then there are the acts that Guy took before the decree was entered, before the temporary orders were entered, on his own. He didn't have to write a check to Candy for $1 million to help pay her expenses. And I could go on, but I don't want to keep Judge Harris from asking this question.
I want to ask a question about that because I think it is, I mean, I'll take your point that it is somewhat remarkable that Guy has, you know, made every single payment. We don't have, you know, at least in the last few years, any complaint from the other side that there's been any missed payments or anything like that. And it is somewhat remarkable in a case like this. But that does kind of beg the question that if he's such a good little payer, why is he resisting so vigorously the request that this be securitized? If he intends to pay everything on the day it's supposed to be paid, then what difference does it make to him if there's a security interest in Candy's name in some of these assets? Because, you know, if he's going to pay, then the security interest is going to go away. It seems there's a lot of energy being spent here to resist security, given his track record.
It's a good question, and I hope that you'll think I have a good answer. It all has to do with the way a large industrial construction company operates. It requires lines of credit. It requires bonds in order to bid on major projects, which is the business of WBC. And none of that is possible if there are security interests in the assets of the company.
Again, granted, but why doesn't he then offer a security interest in his stock in WBC? It doesn't seem like a lender would care about that so much. If we're not talking about the equipment and the assets of WBC, we're talking about Guy's stock in WBC. Why doesn't he offer that?
One short answer is that Candy never requested that at the trial level. And he is also personally liable. He has to provide personal guarantees to all of these sureties and to his bank for his line of credit, which in turn is required in order to get the bonds. So anything that is on his credit record affects the ability of the company to operate. It's that simple. It would tie his hands behind his back by his ex-wife, who has said, in her words, "I don't know anything about construction." What she is asking for is the right to pre-approve all sorts of major decisions that WBC and the related companies would need to make.
But again,
And-
a security interest in his stock is different than asking for conditions or the right to pre-approve. It seems like we're talking past each other a little bit.
No, we're not talking past each other. It's just that part of what they've requested is what I'm talking about. And they haven't actually, I'm not sure that Candy has actually in a cogent way requested an equitable lien, which I think might be what you're talking about, crafted to only affect his interests in the companies. She really didn't mention that until the appeal. So if the court decides that an equitable lien should be considered here, even though it wasn't clearly requested below, I think that what the court would need to do is return the case to the trial court, because that depends on the equities of the case. And respectfully, it's not this court's job to determine those equities, but they have to be determined in the first instance at the trial court level by the judge who heard the witnesses, can make credibility determinations. We know that this judge has dismissed Candy's concerns repeatedly as being just based on fear and unsupported speculation and basically distrust for Guy. And that may be justified on some level. But what the trial court also has done is said he has come through on his obligations. The court made a lot of those findings in the context of dissipation and contempt, but they could as easily be made in the context of paying what he owes under the equalization payment order.
But that runs back to the problem, though. I mean, let's put aside any allegations of his nefariousness. Let's just say that the business conditions turn for the worse in the next 5 years, and that what we're looking at 5 years from now is a company that's worth a lot less. What you'd have Candy saying is, like, 5 years ago, I was awarded half of this really big pie. And now, because of business conditions or because perhaps of his mismanagement, whether advertent or inadvertent, the pie is much smaller. So therefore, my share of the marital estate dropped dramatically for reasons that had nothing to do with me. That seems to be her contention. Why is she wrong in being worried about this being so far out of her control and so far within his control?
Well, I actually think her contention is all much more about the nefariousness
Sure.
that she alleges. But setting that aside, Candy is still going to recover unless this court equalizes the transaction costs. She's going to recover far more than Guy, whatever the value of WBC is in 5 years. There's no reason to believe that any of those events that we've talked about will actually happen. Somebody mentioned, maybe, I think it was Mr. Boer, maybe the best option would be to liquidate right now and divide the proceeds. I think there's a good chance that if the court ordered the trial court to consider that on remand or reconsider it, that at this point, Guy might say, that might not be a bad idea, as long as Candy is ordered to share in those transaction costs that are the subject of our cross appeal in the other case. I don't know, but the fact remains that Candy is relying totally on speculation, and she doesn't have a judgment in the sense of the jury verdict that Mr. Boer referred to. Guy is current on all of his obligations under the trial court's order. In 2024, if he doesn't come through and pay the balloon payment, then she will have something that she can go to court and enforce. At this point, she doesn't have an enforceable judgment. And so we don't think there's any reason, given his track record and given Utah law, which doesn't permit a judgment lien, only permits an equitable lien if the equities of the case support it, which they don't think it does here. Rule 62 does not apply at all because this has nothing to do with staying execution pending appeal. We just don't see any basis for the relief that she's requesting, and we believe that the way the court set it up was well within its discretion. I'd like to return to the reasons why Candy's particularly requested security is not feasible in this case. And this is not entirely in response to Judge Harris, because I know you were focusing on securing his interests. But Guy is a hands-on owner. He's hands-on with WBC, and he's also hands-on with the restaurant. There was evidence and there were findings to the effect that the restaurants were not in great shape. And then Guy, through his active management, turned them around to a large extent by monitoring expenditures and other things. So his role in the restaurants is real. That's one reason why why Candy shouldn't have an interest in them. The other thing is that some of these entities have outside owners, third parties, who would have to, Candy presented no evidence about how these transfers that she requests could be made given the agreements, the LLC agreements with third parties. So that's yet another concern. Ultimately, though, Candy became a full-time homemaker when her first child was born over 3 decades ago, and she has not worked outside the home since then. She has no training in engineering, in business, in hospitality, and the trial court relied on her lack of experience and her lack of skills to say that this just doesn't make sense. Again, was that an abuse of discretion? Could the court have done it differently? Yes, the court could have done it differently, but we don't believe it was an abuse of discretion to do it the way it was and to conclude that no security was required, primarily because of the effect it would have on Guy's operation of the businesses and because there was no evidence that it was required. Let me turn very briefly to the law. I think I've covered it quickly. But I would like to also say that granting Candy the particular security that she requested in the motion for security that is now up on appeal would defeat the clean break requirement under Utah law that Ms. Nelson began her comments with in the preceding appeal. What she is effectively asking for is an unwinding of the division of the marital assets. And she's saying that even though the decree said that each side would have sole authority with respect to the assets awarded to them, now she wants to re-inject herself into the operation of the businesses. She wants to know whether Guy is overspending his budget.
But that's not necessarily true if the only thing that ends up happening is an equitable lien and she just gets a portion of his interest, right? I mean, if the thing that happens isn't her, sitting on the board, but just she gets a lien, that's not true, is it?
Well, that's not what she's requested. And so this court would have to be very careful if it goes that road about how it writes its order. Because what it has requested is literally co-management and approval, veto rights over all sorts of decisions that Guy would normally make in the many times a week while running the companies. And companies as to which Candy literally knows nothing and those are her words, and has also expressed no interest. So we think it would be, as the trial court put it, a very bad idea to do what Candy is requesting. My time is up unless the court has further questions.
Thank you very much, Ms. Glenn.
Sure.
Rebuttal.
Thank you, Your Honor. I have never missed a payment on my mortgage, and I have refinanced many times. And U.S. Bank still wants security when they loan me money, not because I'm a stand-up guy, not because I'm a scoundrel, but because when somebody else has your money, you get a security interest unless there's some compelling reasons not to. The stock and the interest in his stock not being preserved, you can look at page 21 of their brief. It discusses the order that discusses that very request. Oh, I'm sorry, Your Honor. Go ahead.
That was what I was going to ask. I was going to ask you to respond to that argument that the specific relief you asked for below had to do with conditions on the business and a judgment lien and some other things, rather than asking for what we're really talking about here today. And it sounded like you were well on your way to answering that, so I'll be quiet and let you do that.
Yeah, thank you, Your Honor. I mean, we would always throw in any kind of adequate security, as they point out in their brief. This has been asked for 4 different times below, and there are all kinds of different iterations. And certainly you can pick the one that would be the worst and make it out as if that's the only one at issue on appeal, and therefore to be an abuse of discretion. I mean, at this point, this court has equitable authority to impose an equitable lien before it goes back down. And certainly the court can just instruct the district court that it needs to provide adequate security given where Guy's assets are after we get those disclosures in the trial court. That's a very easy opinion to write. Certainly the need for security at all is preserved in spades on this record. And so there is no issue there whatsoever. I mean, one place where we ask for the stock specifically or a lien on the stock is 11910 in the record, an order discussing it at 12333 of the record. It's denied on the ground that it wasn't asked for at trial, which of course is not really the issue. Once you've imposed the payment plan and reduced the 10% interest down to 5% interest so that we have a $17 million balloon payment, even if it's 16 million, at that point, security looks very different, and that is not a reason to deny it. I also want to point out that if all of these assets diminish and it turns out that Guy doesn't do a very good job running the business for whatever reason, you know, maybe factors outside of his control, it doesn't matter, that if they go down and they can't pay Candy, she loses because of the way he administers them. But if he administers them and they double, she doesn't gain. And so this is inequitable on its face. And then when there's no security whatsoever, so that if he's suddenly sick, he can transfer assets however he wants to whatever irrevocable trust he wants to make sure that she doesn't see a penny. The fact that that's possible is why US Bank wants me to give it a security interest in my house if it's going to give me money. And it's why every district court under facts like this should require security in a case like this, where you've got a payment plan like this. And this court doesn't need to determine what would be the appropriate security. Number one, because that does fit more squarely within the discretion of the trial court. But number two, because we don't know the facts on the ground at this point for the court to even to be able to do it. But certainly a blanket equitable lien issued this afternoon would secure things until we can get back down, get an accounting, figure out where all the money is, you know, and if it's right where it's supposed to be and all the payments are going to be made on time, no harm whatsoever. And it is per se an abuse of discretion when you can't put anything on the ledger on the other side and all of the equities are on one party's side. That's the situation here. If that's not an abuse of discretion, nothing ever will be. Thank you, Your Honor.
Thank you very much. All right, Ms. Glenn, if you could just rejoin us just briefly. We want to thank you both for your arguments and briefing. I said this earlier with respect to the previous appeal, but this is a complicated case, and I personally thought that the briefing was very, very helpful in the argument as well. With that, we'll be adjourned in this case. We'll issue opinions in these two appeals as soon as we can. For those who are tuning in for the State versus Rivera argument, we are going to take a 10-minute break, and so we'll begin that argument at roughly 11:10. So, thank you, Counsel.